I now call the case 112449, State of Kansas versus Dustin Dean Perkins. Mr. Holm, we might wait for our visitors to leave just so there's no disturbance.
May it please the court, Michael S. Holland II, on behalf of Dustin Perkins, appellant and petitioner. If I may reserve 5 minutes for rebuttal, please, Your Honor.
You may.
Your Honor, this is a DUI case that I guess stems from this court's previous decisions in State v. Neese and State v. Rice. Simply stated, this is a case where an individual was arrested, was provided with advisories which have now been deemed to be unconstitutional by this court in State v. Neese. No search warrant was obtained, and a breath test was submitted. The question to this court, from appellant's perspective, is did the state prove voluntary consent free of duress or coercion? And it's really no more complicated than that. And the obvious answer, at least from appellant's perspective, is no. They did not prove voluntary consent free of duress or coercion because it's almost a legal impossibility in a set of circumstances. Now, before getting into good faith and search incident to arrest and why it does or does not apply, the first argument for the court is that this court has already addressed this issue. If you look at this case, it is nearly identical to State v. Neese. There was no search warrant obtained. Good faith, importantly, was not argued before the district court. There really is nothing different between this case and State v. Neese. And in State v. Neese and State v. Rice, as you're obviously all well aware, it was your opinions, multiple opinions. This court succinctly held that Kansas had wandered away from search incident to arrest as the basis of the implied consent law and gone off instead into voluntary consent grounds. But the problem is one, you still have to prove voluntary consent, and two, of the coercive nature of both the advisories and of KSA 8-1025. It's exactly the same factual circumstance we have here. This court in State v. Neese and State v. Rice specifically stated on multiple occasions that search incident to arrest was no longer the foundation of Kansas implied consent law and therefore could not justify the search in Neese. For some reason, the Court of Appeals in Perkins didn't think that you meant what you said, I guess. I'm not sure. But in any event, the Court of Appeals in State v. Perkins then adopted this search incident to arrest exception to the warrant requirement.
Why isn't search incident to arrest still a viable warrant exception?
For the same reason this court said it wasn't in State v. Neese.
We did not address it in State v. Neese. In fact, in our order on the rehearing, we specifically limited the issues to informed consent.
As I quoted in the brief, and I don't want to go through it again, I dig it out now, I'm sorry to bring it up with me on for this part of it. But this court specifically said, and there's language quoted from this court that said that search incident to arrest was no longer the basis of the Kansas implied consent law and therefore could not justify the search.
Right.
Under the statute, but the question is, does that wipe away the constitutional common law, if you will, search incident to arrest exception to the warrant requirement?
It doesn't post July 1st of 2018 when the legislature changed the law.
That's my fundamental question. How does whatever the legislature does change the law under the U.S. Constitution?
It doesn't.
Well, that's your argument, that because this legislature chose to pursue an implied consent path, that somehow law enforcement is now limited to that path only.
It's not that, not just that. It's also then what the state argues at the district court level. They're bound by that.
Okay, so that's a different argument, though. That's a procedural bar to raising the issue.
Which was also part of the bar in Neese. And part of the reason this court didn't let them argue that as search incident to arrest is the second. Although the court, I contend, did address and say that the search incident to arrest couldn't save it because the law no longer was relying upon search incidents to arrest. And that's not to have some jurisprudence argument about what the legislature should or shouldn't do, but they could have wiped out all of this nonsense and just allowed the Fourth Amendment to be the Fourth Amendment. They didn't.
Well, they can also make a statutory scheme that is more protective of Kansas citizens than the Fourth Amendment.
Correct.
And so if they intended the implied consent law to be the means by which warrantless searches could be performed on drivers, they could do that.
Correct.
And are you arguing that that scheme was intended to be the exclusive means by which they search for blood alcohol content?
Yes, I'm going to try to give as short as answer as I possibly can. When Schmerber came out years ago, multiple states were concerned with forcible blood draws. And so they passed laws, commonly referred to subsequently as implied consent laws, to try to lawfully coerce people into acquiescing to searches, because the visuals of tying somebody down and stabbing them with a needle and taking their blood was abhorrent to them. It was originally intended to protect individuals and to do blood draws in an orderly manner. As quilts go, or time, or telling a story, whatever else, as time goes, perspective was completely lost. And the Kansas implied consent law lost all perspective as to its original primary intent, and ended up being turned into something that made it unconstitutional. They gave it its own poison pill. They wandered away from search incident to arrest, which is what Schmerber said.
In other words, your argument is that the implied consent law was passed in order to make consent the way in which blood or breath could be obtained, not some other exclusion to the Fourth Amendment. That's your argument.
Absolutely.
Is there any evidence in the statute that suggests that the legislature was telling Kansas law enforcement, you no longer have the authority under the Fourth Amendment to conduct a search incident to arrest?
Well, that actually was addressed at length in both Neese and Rice. It's not so simple as saying, hey, law enforcement, you can't do search incidents to arrest anymore. It's more the legislature keeping on adding layers and layers and layers until they lose perspective of what the original layer was. That last layer they added was criminalizing an individual's ability to refuse.
And I understand that's certainly the decision of the court, that portion of the statute was unconstitutional because it was unconstitutionally coercive. I'm just back to how do you jump from there to the statute means law enforcement doesn't have the authority to act lawfully under the Fourth Amendment to do a search incident to arrest?
Because one, a valid search incident to arrest was never even proven here, if we're just going to get to this case specifically. Two, it was never argued. And three, we still have that statutory scheme, even though it's been ruined by how the legislature's throwing in things that didn't belong there, but it's still this statutory scheme. And until you get rid of that antiquated statutory scheme that has now been added onto too many times to make it functional, you have situations like this, which is why when they finally got rid of it in July of 2018, they finally did the right thing. Kind of, they haven't addressed the blood issue yet. But in any event, it's a whole lot better. But you still have that statutory scheme. You can't just ignore it. And that's why we ended up with the decision that we ended up with in both Rice and Neese, because it still exists. And abandoning the search incident to arrest basis of that scheme was that scheme's own downfall. And it is our clients, and it is the Constitution that protects people in situations like this. And what makes it the easiest is we don't have to get caught up with good faith, because even if the officer was acting in perfectly good faith, fine, it doesn't make the test result admissible. There's nothing about good faith here that makes the test result admissible. The Kansas statutory implied consent law never allows for the admission of evidence. It is prophylactic and requires the officer to do things before a test request can even be made. And so even if you say, yeah, we're going to rely upon good faith, the officer didn't know what he was doing was wrong, okay, fine. Grant you that, it's still not admissible.
The state's primary argument here is that the test did not violate your client's Fourth Amendment rights.
The problem with the state's primary argument is the fact that there's no evidence to support that, and it wasn't argued
Okay,
for
so
the district court.
those are, assume with me for the purpose of the question, that there's no preservation bar and that the state can prove it up. Does that mean that your client loses, or do you have some argument that survives those two hypothetical facts?
We would still argue and contend based upon this court's own words in Neese and Rice that because the state has chosen to interject itself into what you need to do and how you can have a test result admitted, that the sole basis that can be for those test results has to be through the Kansas implied consent law first.
Right. So search incident to arrest is not available.
Absolutely.
Right.
Just let me see if I can put this simply. You're saying that the Kansas legislature has chosen consent to be the only exception to a warrant to obtain either blood or breath for a DUI prosecution.
Correct. And again, I'm not going to bore the court with going into my brief, but there are many times in both Rice and Neese that this court says that. The sole basis is that is what is so kind of an inherent catch-22 the legislature served on itself, is they strayed away from search incident to arrest as a basis, made the sole basis being voluntary consent, and then completely destroyed the possibility of getting voluntary consent when they criminalized an individual's ability to refuse. And they did it to themselves. And this is the precise place that the exclusionary rule should be applied. Because voyaging off with a reservation like this and doing things like this is exactly what should be deterred by this court and other courts. No, this is not good faith. The officer did nothing wrong other than follow his training. But that doesn't get around the fundamental foundational rule: warrantless searches are presumed unreasonable, absent a valid exception to the warrant requirement. The only one that is allowed to apply in Kansas is voluntary consent free of coercion, yet the statute itself is intentionally coercive and criminalizes an individual's ability not to consent. An officer's good faith is nowhere found in that. It still has to be proven whether the officer was completely acting in bad faith or good faith is irrelevant. It is that foundational constitutional protection that has to be hurdled before the state can admit the evidence. They can't hurdle it. See, I'm out of time unless there are any questions.
May it please the court, Chris Elslager appearing on behalf of the state. And of course, the state submits that the Court of Appeals was absolutely correct in holding that the breath test evidence here was admissible under the search incident to arrest exception to the warrant requirement, following both the United States Supreme Court decision in Birchfield v. North Dakota and this court's language in Rice too. The United States Supreme
Elslager?
Yes.
You appeared at that podium a number of times arguing that the defendant didn't preserve the argument. I understand the situation here is different. You've got a change of law, but I think you should defend that you are raising it for the first time on appeal.
Certainly.
Yeah.
And it was raised for the first time on appeal in the Court of Appeals, and we made the case in the Court of Appeals for why one of the three exceptions to the general prohibition applies.
Actually, didn't the Court of Appeals show cause you?
Yeah.
To brief it?
They did.
Yeah.
They did. And then in the brief, I'm almost certain that I'm certain that we briefed why it could be raised for the first time on appeal. And this was one of a slew of these cases. The Court of Appeals had several of them in front of them where we had raised it for the first time on appeal. They showed cause in this particular case because I guess when the briefs were filed.
Is it really being raised for the first time on appeal in a traditional sense, or is this really a case where we have a change in the law applying to a case that's pending on appeal?
Certainly, I would argue that.
Are those the same things?
No.
I mean, our typical law about whether you can raise something for the first time on appeal is founded on the presumption that you could have made the argument at the lower court, right?
Yeah. Well, to be fair, I mean, the state could have argued search incident to arrest in the district court because that constitutional exceptional warrant requirement has always existed and has existed in Kansas law. I would submit it long before Rice and Neese and any of this.
Your position is it endures through whatever statutory changes are made.
Yeah, the legislature can't rewrite the Constitution, so that constitutional exception is there. The good faith argument, of course, wouldn't have arisen until after Rice and Neese. And back to your question, Justice Johnson, there are three recognized exceptions for raising something for the first time on appeal. The first is that the newly asserted theory involves only a question of law arising on proved or admitted facts and is finally determinative of the case. Well, here we have stipulated facts. There is no argument of facts. We have a pure question of law. So it absolutely fits that exception. The second exception is consideration of the theory is necessary to serve the ends of justice or prevent a denial of fundamental rights. That's a much weaker argument for the state, although we have submitted that the state's interest in the compelling interest in safety on the public roads has been recognized by this court, and we would submit that the interests of justice warrant addressing this issue in that context. And then finally, the last one is that the judgment of the trial court may be upheld for on appeal for wrong for the right for the wrong reason. And we have a legal constitutional justification for the court, the district court's ruling, separate, even if its initial ruling may have been wrong. So all three apply, but certainly the first and the third exceptions.
And moving you to the good faith, what statute did the officer rely upon in good faith?
Well, he relied on the 8-1001, the implied consent law, and the officer had no way of knowing that it would be struck down some years later. I mean, he followed and there's no argument here that he did not follow the law. He followed the law as was required at the time. Read the advisories as required at the time. There's no police misconduct, and the whole purpose of the exclusionary rule is to prevent or to deter police misconduct. It's, as the court well knows, it's not in the Constitution. It's a judge-made rule, and the point is, as the United States Supreme Court has said, is with any remedial device, application of the exclusionary rule has been restricted to those situations in which its remedial purpose is effectively advanced, which would be deterring police misconduct. But if there's no police misconduct to deter, there is absolutely no reason.
But bottom line, what this officer relied upon was consent.
Well,
The driver's consent was what the officer relied upon to obtain the intoxilizer results, right?
no, I would disagree with that because it was incident to a lawful arrest, and under the statute authorizes searches both with an arrest and without an arrest. But it authorizes a search incident to arrest, and as you pointed out, the request for consent is not for legal consent. That is for cooperation, physical cooperation. But the legal basis.
Counsel, can I back you up for
yes.
just a second? It seems like what you just said is inconsistent with what you said earlier about the justification of search incident to arrest pre-existing the statute and continuing to endure through any statutory change. I mean, isn't it just an alternative? And if that's true, then what difference if the statute that relies on consent is complied with or constitutional or not?
Well, I think as a constitutional matter, it's of no import. The state statute is of no import when it comes to the constitutional basis for the search. Okay. It is a search incident to arrest.
And how does the officer accomplish that? We had your opposing counsel talk about Schmerber seemed to allow the tackle and withdraw the blood involuntarily, but how do you get deep lung air? Well,
and I know you discussed with my opposing counsel earlier. The officer asked for it. Now, obviously, yes, you're right. The person could physically refuse, but that's not physical cooperation. Is not the same as the more abstract concept of the legal justification for the search.
And I'm sorry. I didn't mean to stop you. Go ahead.
Well, I mean, the Constitution is not grounded on what's physically possible in all instances. We could dream up all sorts of hypotheticals where a constitutional right is not physically possible, but the right is still there, and vice versa. The legal justification is search incident to arrest. Now, the consent request is to get that physical cooperation, but you could physically resist a warrant.
And why is Judge Atchison's opinion correct? And what he indicates is that we have no way of knowing whether this driver would have cooperated had it not been for the coercive consent.
Well, it doesn't matter because as a constitutional matter, he had no right he had no right to refuse.
But it
So as a-
matters as an evidentiary matter because have a conviction based upon the results of that test.
But the evidence was constitutionally obtained and constitutionally admissible.
Only because he cooperated.
But that is
can't-
not consent in the constitutional sense. The constitutional basis is search incident to arrest. It's just like if there is a warrant and the police come to the door, they tell the guy at the door, hey, we've got a warrant to search, can we come in? And the guy says, yeah, sure, come in, search the place. And they say, well, he consented, but then it turns out later that was just the cable guy, and he had no right to consent to a search. The warrant is still valid, and the search is still valid on the warrant basis, because the warrant was the constitutional basis for the search, not consent.
One of the ways to get deep air lung is to hit the person in the stomach, right?
I wouldn't know.
Well, sometimes you exhale when you get hit in the stomach. You know
Yes,
that, right?
okay.
Would that then be permissible?
I don't know if committing a battery on the person is. I mean,
Well, it's constitutional. You said.
that's getting into the but then you could be violating other constitutional rights there. I know that.
Okay.
You're going down hypothetical into the realm of perhaps torture and so on, which I just don't think is really realistic.
Let's talk about attenuation. If this officer could have exercised somehow, maybe running an Arkansas bluff to get acquiescence, even though they don't get consent voluntarily. But I lost my train of thought.
Happens to me standing up here all the time. You notice. Ultimately, let me get my train of thought.
But if I think, to follow up, I think attenuation is important to consider. Because if there was an unconstitutional advisory, do we have to move away from that in some way? Does that become relevant, even under your theory?
Well, again, let me think about that a moment. I mean, because I hadn't considered attenuation, but the state's point, of course, is that the search incident to arrest exception to the warrant requirement justifies obtaining the breath test. So even though the advisory, which is a state law animal, may have been incorrect, that doesn't trump the constitutional basis for the search.
Well, where I was going with that when I had my senior moment was if you have an unlawful search that is followed by a consent or something other, we have said that you have to have a break in the action to attenuate the unlawfulness. That's where I was trying to get at. And I'm asking if you obtained a coerced consent, even though you could have used some other exception, if you haven't attenuated that unconstitutionality, how can you use that other exception? This is kind of where I was getting at. Do you understand?
Well, I really don't think that attenuation comes into play because, of course, my position is that there was never an unlawful or unconstitutional search. And I think the case law says that the state only has to prove one lawful grounds for admission of the evidence.
The problem is there was an unlawful consent obtained, or consent was obtained unlawful.
There was, of course, cooperation, physical cooperation. I would argue it's not the same as legal consent.
Well, but you lost that argument in Rice and Neese, right?
But then after Birchfield, this court revised Rice, and Rice 2 said, we further modify Rice 1 to reflect the validity of conducting a breath test in a DUI case where an arrest is made under the warrant exception of a search incident to a lawful arrest. I mean, to me, that's very clear. The court has recognized Birchfield and says a breath test is admissible as a search incident to lawful arrest. From my standpoint, then we're done. I mean, we've won. You would have to go.
You don't need to attenuate an independent basis.
Right.
And the independent basis is categorical,
Yes.
not individual.
Exactly. And so then, I mean, the United States Supreme Court has said, made a constitutional ruling that is the case. We're bound by that. So the only way that the defendant here can move into some kind of a violation would be just purely a matter of state law. and some kind of express state protection. And I would direct the court to City of Dodge v. Webb, where another DUI case, this court said, when law enforcement officers properly authorized to execute the state's police power act within minimal constitutional parameters, both federal and state, such acts have a presumption of lawfulness unless expressly prohibited by a state's enactment of greater protections for its citizens. There is no express language in the implied consent law that says that we are limiting the constitutional basis for police officers to obtain evidence to just consent. There's no language in there that would limit it to that. And it had long been recognized that, in Kansas, that the implied consent law was a search incident to arrest. It was broadened, I think, in 1985 when they added there were other, in the statute, other certain circumstances where an arrest wouldn't be obtained or wouldn't have happened where it was authorized, such as accidents and so on. And that was where then a broader scope had to be applied. In those cases where there wasn't an arrest obtained, well, then you would have to get consent or have some other constitutional basis for the breath test. But in the cases where there is an arrest, the United States Supreme Court, as this court has recognized, has said there is a lawful constitutional basis to obtain a breath test.
And so my sort of theoretical question is, under your theory of the case and the law, could an individual who was under arrest and subject to a search incident to arrest, who does not cooperate with the giving of deep lung air, be charged with and convicted with obstruction?
I think you could. The same way as if the police come to the door with a warrant and the guy shuts the door and locks it up and barricades himself in and won't let him in and flushes the evidence down the toilet. I think that too could be obstruction. Of course, everything depends on the facts presented, but I think that's certainly a possibility. And I think in Birchfield, the Supreme Court didn't make that decision, but it did intimate that it could be. And if there are no further questions, that concludes my argument. I would ask the court to uphold the Court of Appeals. Thank you.
May it please court. It is important for this court not to lose sight of the fact that this case is identical to State versus Nice. The general arguments made before the district court are the same. The general timing, even the age of the case, is almost the same. Every single thing is identical. The state chose, at the district court level, to rely upon the statutory scheme for the admissibility of the test results. They did not argue, rely upon, nor bring up search incident to arrest. There is no factual basis to argue search incident to arrest. This court before in Nice, when the state attempted to argue search incident to arrest and asked the court to modify its decisions in both Rice and Nice, refused to allow them to do that, other than saying, yes, constitutionally speaking, search incident to arrest, if it's a valid arrest and it's a breath test, may be available to the state to argue. May be available to the state to argue. We are here today based upon this case, not some other case, not based upon what they can argue now, not based upon the current statutory scheme that went into effect July 1st of 2018. We are here under the statutory scheme that was put forth by the legislature in this case, which is the same as it was in Nice.
You've said twice, no factual basis for search incident to arrest. Opposing counsel argued that it was categorical. And if it's categorical, it's not based on case-by-case facts. So what's the factual basis that needed to be established at the district court in order to bring a categorical exception into play?
Search incident arrest, although addressed by Birchfield as a general possibility of an exception to a breath test, doesn't mean that every single DUI case ever has search incident arrest that would be available to it. You still also have to prove up some foundational factual issues. You have to prove a lawful arrest. You have to prove a search that was incident to that lawful arrest. You can't just come in 5 years later and go, well, hey, we really should argue that all the way back then. That would have been really smart for us to do instead of putting all of our eggs in the basket of a law that's now been declared to be unconstitutional. That would have been smart, but they didn't.
Are those facts not in the record? Is that what you're arguing? Because the state says we have all the facts we need. It was stipulated to. It's a pure question of law.
Well, stipulated to when the state's already put forth their legal arguments is entirely different than, oh, wait, we're going to change our legal arguments. Well, then that also changes what facts would be stipulated to and which wouldn't be. If the state at that time had wanted to argue search instead of arrest, we would have needed to have an evidentiary hearing because I sure as heck wouldn't have just stipulated to that. Because that would have been an entirely different issue.
If that did get stipulated to, aren't you stuck with it?
No, we're not stuck with that because just the same as then they're stuck with whatever issues they raised at that level. I'm fine with being stuck with with whatever facts were stipulated to in regard to the issues that were raised. If those issues weren't raised, then it completely cuts us off at the knees because then we can't contest facts that are suddenly relevant to a new issue. This is a new issue, which is the same reason the court wouldn't consider it in Nice. And it may be a lawful exception, maybe now, especially under the new law, but back 5 years ago, when the state was just saying, just as they did in Nice, this is a consensual search under the Kansas implied consent law. They can't change that argument now and go back and try to backfill in a record with arguments that weren't even made before the district court or originally before the Court of Appeals and expect my criminal client to be bound by those with new arguments and new issues. That's not fair. And it's why the court doesn't allow issues to be raised for the first time on appeal. It's why this court denied.
Well, one of our exceptions is if it's a pure question of law based on undisputed facts. And I'm just trying to get at the undisputed fact portion of
It's
that.
not a pure question of law, and those facts would have been disputed. Because that would have been an entirely different issue that required entirely different facts. And so, no, it's not an undisputed fact of law. Yes, as far as what was the argument as far as search and arrest as a legal, venture, sure, that is a question of law. But the facts and what would have been stipulated to and what would have been presented to the district court would have been entirely different.
In what way?
Well, as a defense attorney, if they wanted to argue search and arrest, I would have made them prove up an actual valid stop. We would have argued about the admissibility of the PBT, which has now been found to be unconstitutional. In State versus Robinson, we would have argued about the admissibility of the HGN. We would have gone through the whole thing and had a full-blown evidentiary hearing. But in order for judicial economy, because everybody agreed, prosecutor and defendant alike, these are the issues, these are the facts relevant to those issues. Sure, we can stipulate, save everybody an evidentiary hearing, save everybody a jury trial, and take it right up on appeal. But it's not fair to now say, oh, wait. We wanted to raise a different legal issue down there that would have different facts relevant to it. And so you're supposed to be bound by those facts that didn't even have any application to the issues that were raised. That's not fair.
Since we're in the niceties of preservation, did you argue in your petition for review that the Court of Appeals erred by applying one of the exceptions to raising an issue for the first time on appeal?
I don't have my petition for review in front of me, but I'm sure I did. At least I think I did.
I don't see it.
I know I argued that they ignored this court's decision in Rice and Nice, and this court's decision in Rice and Nice was based upon the premise they couldn't raise those issues for the first time on appeal. So yes, it would be argued.
Okay.
If there's nothing further,
Anything further?
thank you.
All right, thank you, counsel. The court will take this matter under advisement.